Hello, good afternoon, and welcome to the third annual New Jersey Youth Transition Conference. My name is Lisa Daup, and I represent the Camden County Partnership for Children on behalf of the Youth Transition Conference Planning Committee. This afternoon, our presenter will be Jason Miller, and he's from Plan New Jersey, and he will be presenting on the topic, Person-Centered Life Planning. Who will care for my loved one when I'm gone? For this workshop, we ask that you hold off any questions until the end, and the presenter will be happy to answer any questions that you have. So with that, take it away, Jason.
Thank you. Okay. Okay. Good afternoon, folks. My name is Jason Miller. I am the Director of Social Services at Plan New Jersey. So tonight we're going to have a variety of topics that we're going to cover. We're going to speak about life planning, which is really putting together what is the plan, the legal plan, financial plan, where's a person going to live, how's it going to be paid for, those pieces. We're going to talk about guardianship as well as alternatives to guardianship. So the reason for that is some folks, their limitations might be profound enough where there needs to be court intervention, but for everybody else, it's good to have some alternatives to provide some protective features as far as making sure that an individual is free of exploitation and things along those lines. We're also going to talk about special needs trusts and ABLE accounts. I think everybody's pretty familiar with ABLE accounts, but I always like to make sure that especially when we have families that are coming to these, that they can utilize, one of those tools that are out there that aren't as exhaustive or complicated as creating a special needs trust. So the organization that I represent is Plan New Jersey. So Plan New Jersey is a private nonprofit organization. We were established back in 1988. Actually by a group of families that really were uncertain as to what happened. So there's a place for someone to live, a place for someone to work. There's a lot of different state services out there, but who is actually going to serve in that role where, okay, if I don't have a brother, a sister, or other same age children, who's going to be that independent party that will actually look after or someone and be that continuity of care. People change agencies, people change programs throughout the course of, residing in the state of New Jersey and working within that social service system. So the families, came together and that's ultimately how we were established. Plan New Jersey serves in a lot of roles. So we serve as trustee for special needs trusts. We serve as guardian, representative payee, for folks that we're providing other services to. We don't have a program that we've launched to work with everybody in the community, but we do serve as representative pay if we're delivering any type of other service. We create life plans, which we're going to cover actually first this afternoon. Case management, advocacy. The biggest thing that most parents are concerned about are who's going to tackle the myriad of paperwork that you have when you're just dealing with benefits in general, right? Who's going to do a Medicaid renewal? Who's going to respond to Social Security if Social Security is sending letters? And that's one of the major functions that we provide. So without further ado, let's talk about what exactly a life plan is. It's fairly self-explanatory in the name. It's creating that plan for the rest of someone's life. When we talk about the plan itself, what we like to do is establish that each person has their own individual and unique needs. So, what a plan for Tom is not necessarily going to be the same plan for Sally. So, when you're creating a life plan, what you're trying to do is write down those very specific details that make a person tick, right? What are their wishes? What kinds of things do they like to do? What do they not like to do? And then once you've established very specifically what what an individual likes, doesn't like, what's the routine like. It's part of creating the resources to do that, right? It's, where's a person going to live? Where are they going to go to school? Where are they going to work? How are they going to pay for things? Who's going to manage the finances for, you know, eh, for whether it's money's left behind, whether it's representative payee funds, what are those resources going to look like? And then ultimately it's creating a process by which that who is going to take over those roles. If we're talking about guardianship, who is going to be that successor guardian? Is it going to be a same age child? Is it going to be, a cousin? Is it going to be, an entity or an agency that takes that over? Same with power of attorney or healthcare proxy. Who's going to serve in those legal roles? And then those financial roles, right? So who's going to serve as trustee? Who's going to serve as representative payee? Who's going to make sure that those financial pieces for all the things that an individual may need to pay for is going to, is going to function properly. And then the biggest piece is who's going to be there to, provide that coordination of, medical care, residential care. Who's that going to be, that continuity, and that person that is, that person or group that is going to actually be there no matter where that person goes, right? So one of the things when you're creating a life plan is how do you even start, right? It seems like it's an overwhelming task, but a lot of it is really just starting to figure out what are the things that are important in a person's life, right? So this is one of the Charting the Life course, and I'm sure you guys have come across this over the course of this conference. These are just great tools. This is just one of many. I normally include a lot of these in this presentation just because the tools are very helpful in just kind of kickstarting the idea of like, what are the things that are important? How am I going to even start this process of life planning? Going from, not having anything written down to, formulating that trajectory of the life that we want my loved one to live. So in this one in particular, I like, and it's just the star map, and in the center of it we have Connor. As far as Connor goes, there's a lot of components to Connor. He's not just a person that may have limitations. Connor has relationships, mom, dad, Lily, Peyton. These are the important people in his life. These are the people that help him with a lot of these different things. Strengths, what kind of strengths and assets does Connor have? He likes, he wants to make friends. He likes to laugh. He likes to learn. Ever so important these days is technology. What kind of technology does Connor have that's going to help him access his external world? This obviously became very important over the last several years. These are the things that he can use that help maintain his independence, right? And then community-based supports. He likes to go to scouts and things like that. So even starting these kinds of things at this juncture help you establish what are the things that Connor likes, right? So when we talk about a life plan, when we talk specifically about what a life plan is, it's really taking the things that are in your head and putting them down on paper. Because one of the issues is that, parents have story after story after story after story. They know what works, they know what doesn't, but that information, if there's no transfer of information to a written document, what happens is that information just gets lost over the years. Things that have been unsuccessfully tried before might be repeated. You have situations where you can put somebody in a situation where they really don't like. And this is especially important for folks that maybe don't have verbal communication skills or, a way to really communicate that. So what a life plan really is it's really advice to future caregivers, advice that they can, that they can rely on, that, in the case of Connor, would be very helpful as far as, giving him the life that he would want. Okay. So you can't really talk about life planning unless you talk about what are you planning for, right? So when we talk about life planning in the way that you're mapping out those roles, both legal, financial, and things like that, it's important to establish what exactly is. And part of what we want to talk about tonight is really, what is guardianship. A lot of people don't really know what guardianship is. They might have a rough idea of it, but there are certain specific things about it, that from a legal aspect that are really important that everybody understands. So when it comes to guardianship, at the age of 18, 12:01 a.m. on we'll stick with Connor's 18th birthday, he will become his own legal guardian. Okay, meaning he doesn't have a guardian. So that's a right that's afforded by the Constitution. It is not something that doesn't matter whether there's disability involved or not. At 12:01 a.m. on that 18th birthday, Connor becomes his legal guardian. So let's assume Connor has a significant, profound disability, that maybe he's got severe autism, nonverbal. That's irrelevant. He still has to go through that process. Mom and dad don't get to make that determination that Connor needs to have a guardian past the age of 18. So what has to happen is that it's a court process. So in essence, around the 18th birthday, and everybody gets hung up on 12:01 a.m. on the 18th birthday. There's nothing magical that happens, on that 18th birthday, and the likelihood of you getting a court date on that birthday is slim to none. So the question is what do you do in that scenario? Well, in essence, it's not an emergency. So, you might want to start planning a few months before someone's 18th birthday, as far as if you're going to go for that guardianship and try to do that. The reason being is you can't actually file any papers until the person actually is at the age of majority. So up until that 18th birthday, in Connor's case, mom and dad are legal guardian. And it's only after that 18th birthday that you really can make a petition to apply for guardianship for that individual. So so the big question that I often get is, so what do you do in that time frame? And the answer really is nothing. Unless something comes up that's very specific, needing guardian consent on that birthday or within the first couple of months of that birthday, there's really no need to push that issue. Ultimately, if there was an emergency and you're not the guardian, you can actually apply and get a temporary emergency guardianship relatively quickly. It doesn't take the long process that a standard guardianship would take. So that's it. So guardianship has a couple of different components to it. So, we don't just simply look at in terms of, does an individual have a guardian or not have a guardian? There's actually some subcategories within guardianship. So there's guardian of person and guardian of property. And then even within there are even more things. So like someone might have a guardian of the property, but they can manage their own Social Security benefit, right? Somebody might be guardian of person for medical decision-making and residential, but that person might be able to, decide where they work. So everything gets outlined and it's very specific. The judge is supposed to provide the least amount of restriction that is necessary for that person to live independently. Okay. So the way the process plays out, it's handled in what's called the surrogate court. So that's the place where wills and trusts are probated. So that is actually the section of the court. So there's criminal, family court, and civil court, and actually the surrogate court is part of that civil section. They're the actual entity that manages, records wills and deeds and things along those lines. So they manage that property after someone passes. They also supervise adult guardianships. So when someone becomes legal guardian for another person, they actually are a representative of the court, because that court has ultimate authority over that adult guardianship. It doesn't matter whether you're mom or dad, you still have to answer to the court because that individual is an adult with a guardianship. So the way guardianship happens is, it starts with a petitioner. So you're alleging that Connor does not have the ability to govern his own affairs. So in essence, like any other court case, you're going to compile evidence. In the instance of a guardianship, your evidence is medical evaluation. So, a person would need 2 affidavits signed by physicians indicating that Connor is unable to govern his own affairs and in what specific areas. So in essence, you can use a a psychologist, you can use a primary care doctor, a neurologist, a psychiatrist, any of those professionals that have, expertise in the brain and functioning and how it might pertain to an individual's ability to govern their own affairs. You can't use, say, a podiatrist or a kidney specialist or any of those kinds of things because they don't have that expertise. Okay, so once those affidavits are completed, that's going to get submitted to the court. And then if there's any other evidence, the judge is going to hear that evidence at a hearing. Sometimes they do it, without any, major hearing. They may do things what's called on the papers, meaning they'll just review the case, they'll review the information, and then render a decision. But in most cases, an individual is going to have the ability to have that information reviewed by their attorney. Even if they have a profound disability, they're going to be appointed an attorney to represent their specific interests. And then, what will happen is the judge will take in all of that information and then render a decision of whether Connor needs a guardian, doesn't need a guardian. And then beyond that, what does he have? Limited guardianship, meaning he only needs a couple of pieces of help in these specific areas, or does he need what's called a plenary guardian, which is a guardian for all areas of care. And then once that's completed, let's say Connor's mom and dad had applied for guardianship. They would, let's say the judge had awarded guardianship to them, then they would, get a signed order indicating that, and then they get what are called guardianship certificates, which is effectively their identification that they are the guardian for Connor. Okay. So once you become guardian, what are the duties of guardianship? What are the responsibilities of being a guardian? You have to make personal visits. The statute says you have to visit every quarter. That seems a little infrequent as far as I'm concerned. It's very hard to provide guidance and decision making for an individual if you're only going to visit them on a, say, quarterly basis. You have to report to the court, like I had previously said. Because you are a representative of the court, you need to make sure that you're sending in on an annual basis the report that Connor's been to the doctor, he's been to the dentist, he's getting ongoing care for whatever chronic treatment, chronic conditions he may have. You're going to give a small assessment of how he's doing overall. And then beyond that, there's the duty to provide the moral, ethical aspect of guardianship is your job is to try and help Connor live as independently as he possibly can. Right. So, the idea is really to ensure that, Connor is well cared for, that he has access to stable home, medical care, work if he so desires, day programming, so all of those things, transportation to those things. But beyond that, and again, depending on what Connor's needs are, the bigger picture is the guardian is really responsible for making sure that, they're breaking down any barriers to meet Connor's needs. So, guardianship isn't really about saying, no, you can't do that, or yes, you can do that. It's really about, working with the individual specifically, and then finding out what it is that they want and assuming that it's, safe and reasonable to help that individual achieve that, all the way up to, revocation of guardianship. So it's called return to capacity. So what that means is that, sometimes guardianships are a temporary thing. You see that a lot more with individuals with brain injuries and things along those lines, where maybe they need a short-term guardian and then they regain some capacity. So, it's part of the guardian's responsibility to ensure that person has the ability to have their day in court and be heard if they're expressing a desire to return to capacity. Okay. All right. So guardianship, again, is not the only form of protection out there. So they have other things that can be done. So, again, because everybody is so unique, sometimes a guardianship it's not practical, it's not appropriate. It may create a lot more harm to a relationship by trying to get a guardianship. So there are other alternatives out there. So powers of attorney and healthcare proxy are just one of them. Representative payee for Social Security and trust and special needs trust administration is another way. When it comes to power of attorney and healthcare proxy, and really they're essentially the same thing. Power of attorney is a little bit more broad. Power of attorney is for financial. You can open up a bank account for an individual if you have a power of attorney. Healthcare proxy is just limited to healthcare decision making. So the big difference between these is one, they're a lot less expensive than a guardianship, right? So, if you go through, through guardianship, you're more than likely going to hire an attorney. In fact, I would recommend that because it is a complicated process that's fraught with a lot of deadlines. A power of attorney or a healthcare proxy you can do in an afternoon in an attorney's office. So the big difference between a power of attorney and a guardianship, or a healthcare proxy and a guardianship, is that the latter is these two are ultimately verbally revocable. So what that means is that if you have a power of attorney, let's say mom and dad, instead of getting a guardianship, they just have a power of attorney for Connor. Connor isn't really happy about that. So let's say Connor goes into the hospital and he's getting some medical treatment. Mom or dad call and say, "Oh, I'm power of attorney for Connor. Can I get this medical information?" They still have to ask him for consent if he's awake and able to respond. And if Connor says no, then effectively your power of attorney is revoked. So it won't outlast an individual's consent or denial for information. Okay. Whereas a court, when it's a court-sponsored guardianship, you actually have that documentation. A judge has, returned a verdict, and you effectively have, court backing that says that you're entitled to that information. Connor doesn't necessarily have the right to revoke it. Only a judge has the right to revoke it. Okay, so that does not make these documents by any means useless. Sometimes they're a necessity, and dependent upon the relationship that Connor maybe has with his parents, maybe that's just as well. The issue becomes when we kind of reconcile that with life planning. Mom and dad might have a great relationship with Connor and can do guided decision making, but what about in the future when mom and dad aren't there? So these are considerations. They're good documents, and quite honestly, they're just good documents to have anyway. We had a situation where an individual with mental health issues, he did not have a driver's license, had some significant psychiatric issues, and his parents did not have any documents in place, not a guardianship, power of attorney, or any of those things. While this individual became symptomatic, he had actually gone and purchased a vehicle. He had gone to a car dealership, signed for a car, managed to get a car loan, all of these things, and did not have a driver's license and was subsequently hospitalized thereafter. When the parent had gone back to the dealership and said, "Hey, I'm really sorry about this. My child, has some psychiatric limitations, and you really can't buy a car because he doesn't have a driver's license." Car dealer was like, "Too bad, we sold the car. We'll buy it back for you, but we're gonna only give you back X amount of dollars on it." In that instance, he tried to actually call the place that had provided the car loan, and ultimately they wouldn't talk to him. So if he would have had a power of attorney, that would have been something that he would have been able to do. He would have been able to navigate that situation, speak with the necessary parties to help, squash that transaction. So I don't want to discount it. It's not as powerful as guardianship, but it can still be a useful tool. On the financial side of things, representative payee and trustee are two very, very important roles. Representative pay obviously is for any benefits that are coming in for Social Security, so SSI or SSD. If you have somebody that's overseeing, that financial care for an individual, you can prevent a lot of exploitation, right? You have, the role of the rep payee is to make sure all of the appropriate bills are paid. So a person has that stable housing, they pay the rent, they pay for groceries, you can take care of a lot of basic needs just with that representative payee function. And it lessens the likelihood of an individual being exploited. So a friend saying, "Hey, can I borrow money?" Or, it'd be a good idea if you lent me this money, or whatever the case may be. So it's going to minimize that ability for someone to, exploit an individual in that way. And a trustee is very similar. We're going to get into special needs trust next, but ultimately when we're talking about, extra money, that's held in a trust, when you have a trustee in place there, that's going to prevent, an individual from again, being exploited financially. And if we're talking about much larger sums of money, that's extremely important. All right. So let's talk about what a special needs trust is. So special needs trust is effectively a vehicle for money that is above the resource limit. Okay, so everybody knows the Medicaid resource limit is $2,000. If you have more than $2,000 in your account or in your name, you effectively are ineligible for Medicaid. So if Medicaid requests a redetermination, they can say, oh, well, you have more than $2,000. Unfortunately, you are now disenrolled from Medicaid services. Now, if we're talking about an individual who's enrolled in, not just doesn't just have SSI or SSD, but also has, DDD services, things that Medicaid pays for, they're going to be disenrolled from not just SSI, but they're going to be disenrolled from Medicaid and so on and so forth. So it can have a cascading effect on benefits, that are necessary for an individual to live. So if Connor was residing in a residential group home and was over-resourced or inherited money or whatever the case is, had more money than $2,000, he's going to be in a world of trouble because the Medicaid pays for his services. So that's it. So there's a couple of different types of trust. Okay. So when we talk about where trust money comes from, is really important. The best way to really explain a trust, let's say Connor, we're talking about Connor. Connor has, let's say, a significant disability. And today's example, we're just going to talk about, let's say Connor has SSI and Medicaid. There's about 75 different varieties of how you can get Medicaid in the state of New Jersey. So, we would be here effectively for days to go through every scenario. But, the most basic scenario of where Connor has SSI, let's say Connor is living in a residential group home and he's got a sister, Sally. Okay, so you got Connor and Sally. Sally is neurotypical. That's Connor's sister, and their parents pass away. Okay, so mom and dad pass away. Let's say they have $200,000 in their estate when they pass away, and the will is split up two ways. So each child is going to get 50%. So Sally gets her $100,000, says thank you very much. There's no impact to Sally because she's not on any public benefits. Connor, on the other hand, Connor gets $100,000, and Connor's going to lose all of his benefits because now he is over that resource limit of $2,000. Okay. So the other thing that's important to note is that, there's a misnomer out there that Medicaid is insurance. Medicaid is actually a lien. It's a lien on future assets. So ultimately, by Connor getting that money, okay, he has those resources in his name. Okay. The only way for Connor to keep his benefits would be to create a different kind of trust called a self-settled. Okay. In essence, okay, when you have mom and dad that are passing away, if instead of giving the money directly to Connor, they can, instead of that, put the money into what's called a third-party special needs trust. So in that same scenario, Connor and Sally gets her $100,000. Instead of Connor getting his $100,000, it's going to go to the 2023 Special Needs Trust for Connor's benefit, a name like that. And instead of that money going directly to Connor, it's going to go into a different fund, and it's going to be managed by a trustee. And because of that, it has no impact on Connor's benefits. So he has the ability to be a beneficiary of those funds, meaning that he can have purchases made on his behalf. He can, have, an individual, he can have, television, clothing, travel, all different kinds of things without the money actually coming into his name. Now, what he needs, though, is a trustee to supervise that situation. Okay, so Connor doesn't have the ability to spend the money on his own. He has to have what's called a trustee that oversees those expenditures, but ultimately there'll be no net impact to his benefit. In the first scenario where mom and dad had given $100,000 to each, Connor's going to lose his benefits, or he has to take the money and put it into a first-party special needs trust. And if he puts it into that first-party special needs trust, when Connor passes away, whatever money's there is going to go back to the Medicaid program. So it's going to go back to the state of New Jersey. So Sally's money is always protected. Sally's money is over here, and there's no effective penalty to giving the money to Sally. But in Connor's case, if you gave it directly to him, he would have to create that first party special needs trust. Now, if the parents provide that planning in advance and create third party because it is their money. Okay. What's going to happen is Connor, if Connor passes away and there's any money left over, instead of that money going back to the state of New Jersey, it can actually go to another remainder. Let's assume that mom and dad want it to go to Sally, his sister. Okay. And that's really the big difference between planning in advance versus not doing that effective plan. Okay. So if there's nothing else you take from this, it would be that, if you're working with a family or if you're a family yourself, you want to make sure that they're aware of making sure that they do the planning in advance to create a third party special needs trust, because what it does is it prevents, having to pay back that Medicaid lien that parents ultimately are not responsible for. Okay. So, all right. So this is kind of, and you guys are going to get these slides because it can get fairly complicated as far as like trying to figure out what is a first party, what is a third party. But the most important thing that you understand is that, if an individual, if the individual themselves, who's a Medicaid recipient, Social Security recipient, if they have money in their name, if they want to put that money aside, they would have to put it into what's called that first party or self-settled trust. And with that comes the penalty of, if there's any money left over there when the individual expires, they're going to have to pay back whatever Medicaid lien is there. So when we talk about a Medicaid lien, what is that? So a Medicaid lien is, every time you utilize Medicaid services, so you go to the doctor, you go to the hospital, and you use your Medicaid card, there's actually an account that you have attached to that number that says that this is how much you owe back. Okay. So, if Connor's living in a residential group home and he has a budget of, let's say, $150,000 a year, that means Connor has effectively a Medicaid payback of $150,000 a year. So when you think about how large of a number that could be, when he passes away, he could technically owe $500,000, $1 million back to the Medicaid program. So if that money, any money that's in a self-settled trust or a first party trust, is going to go back to the state of New Jersey to satisfy that Medicaid lien. So essentially what the parents need to understand is that they don't have to do that. If they put the money in that third party trust, meaning they've set it up before they've passed away and directed in their will to put that money into a third party trust, they're gonna be able to keep that money within their family. So oftentimes people say, well, why don't we just give the money to Sally? So Sally will take care of Connor and we don't have to do any of these things. So the big fundamental deficit with that is that we don't know what happens to Sally, right? So let's say that same scenario, mom and dad, instead of giving half to each, they give all of it to Sally. Well, what if Sally's married and then her marriage doesn't go so well and splits up with their spouse? Well, that's going to be part of their marital assets. Well, what if something happens and Sally passes away? Well, that money is going to be dispersed into her family. It's either going to go to her spouse, her children, or whoever the case would be identified in her will. There's a lot of things that you can't plan for, a lot of contingencies that you can't plan for. And because this exists, and that's actually the reason this exists, because what it does is it allows somebody who's very vulnerable the ability to have, some money that's available to help pay for care above and beyond what Medicaid and Medicare don't pay for. Okay. So different things that a trust can pay for. Trust can pay for tuition, trust can pay for clothing, utilities, cable. I mean, people think that, the cell phone is a basic necessity. Everybody has one now. It's still something that can be paid because it's not really a basic necessity. So in essence, a trust can pay for anything that Medicare and Medicaid won't pay for. Dental work, car, transportation, public transportation, insurance, funerals, really pretty much anything that you could imagine. The only thing that it really can't pay for at this point is food. And in most cases, it can't pay for shelter. And the reason why I can't pay for shelter is because that's what Social Security is for. Social Security is supposed to be there to meet your basic necessities of food and shelter. Now, you can, if someone is on SSI and let's say that they need help paying rent, you can utilize a third-party trust to pay for rent, but you're going to get a reduction in your Social Security. Just like if Connor is on SSI and he's living at home with mom and dad, he's not going to get his full SSI amount. He's going to get a 1/3 reduction for in-kind support and maintenance. It's called an ISM reduction. So, it is possible, but ultimately in most cases, what you're looking at is utilizing the trust to pay for the extra things that are not covered under an individual's entitlement. Okay. All right, ABLE accounts. So ABLE accounts are relatively new. It says 2014, but New Jersey didn't actually legislate it until probably about 2017 or 2018, where individuals where they were able to have their own New Jersey ABLE account. Previous to 2018, individuals had to set up an account with Ohio or Pennsylvania, one of those places. But in essence, when we're talking about that resource limit, so we're talking about that $2,000 resource limit for Medicaid, what an ABLE account does is it allows an individual to have money in their name that's above that $2,000 resource. So remember, we said that $2,000 resource, if that money's in your checking account, that's a problem, right? Because if you got $2,500 in your checking account, you're effectively ineligible for those benefits that you're on that are necessary. So they created this, which allows an individual to save up for a vacation, allows an individual to, have that resource limit of $2,000, but then also have these monies that can be utilized for their disability. So it prevents somebody from losing those benefits by having it enabled. So on any annual basis, you can add up to $17,000 into an ABLE account. And this is great when you have an individual that's, say, collecting, SSI or SSD, usually Social Security disability, and then maybe working on top of it. So an individual has a part-time job, so they're getting both a Social Security payment and as well as some income from work. It's very easy to go over that resource limit, especially if someone's, let's say, living at home, right? So you can actually put up to $17,000 a year without penalty into an ABLE account. Okay. The only real criteria for creating an ABLE account is that you have an established disability prior to the age of 26. And people say, well, how do I prove that? Well, if an individual is on Social Security, that is effectively proof that you have a disability, because when you apply for SSI or SSD, the primary reason you're getting it is because you have some sort of disability, right? So whatever Social Security has determined is your disability, and that satisfies this requirement. One of the other things, you can only have one ABLE account, so you're only allowed to have one. You can't put 17,000 in this ABLE account and 17,000 in a second ABLE account, and then you have a max amount of $100,000 before they turn off your SSI. I've never seen anybody have that amount. I can't really speak to it, and I would honestly say that that's probably not the best place to have it. Mostly because if something were to happen to Connor, let's say Connor had an ABLE account, when we talked about first party versus third party trusts, right? When you create an ABLE account, okay, what you're effectively creating is a first party trust agreement with the state of New Jersey. So I'm going to put money in there, and then if something happens to me, well, Medicaid has first right of recovery to an ABLE account. Okay, so when people think, oh, well, instead of opening a trust, I'm just going to open an ABLE account. Remember that it's a great place for Connor's money. If Connor's working and putting that money in there to help keep him under his resource limit, it's an absolutely terrible place for parent money. And the reason being is because once you put it into the ABLE account, that money is in play to be recuperated by the state of New Jersey. Because once it goes into that, it's actually in Connor's name, okay? Because the ABLE account is in the individual's name. And then effectively, that money becomes his. So if something happens to him, that money does go back to the state of New Jersey because Medicaid has that first right of recovery. Right. Okay. So in essence, these are the things that we can do at Plan New Jersey. We can serve as successor guardian. So all of the things that we talked about tonight are things that roles that Plan New Jersey serves. We serve as legal guardian. We do a lot of sibling guidance and family support. And really what that is you may have a legal guardian, you may have a same age child, and that can serve as legal guardian, but maybe they live in California. That doesn't typically work very well in the state of New Jersey with the judges. They don't typically like to see a guardian that's that far away. It makes it very hard for them to have a very impactful, an impact on an individual's life in any real way, because it's just not practical for someone to be 10 states away. We do life planning. So when we talk about life planning, we have a very specific format that we utilize. So a lot of times families will come to us to organize, that life planning feature. Where's a person live? What kind of medical care do they need? What's their routine? What do they like? What do they not like? All the way up to, what happens if you get bad news at a doctor? How would you like that handled? So a lot of families will come to us to help guide them in writing that life plan. We do case management, so for the folks that don't necessarily need guardians, we do a lot of it's what's called home visit monitoring and support for parents that have really been a driving force and have kind of been the de facto guardian, even if they never went to court to do that. So we serve in that case management role to make sure that all of those things that we talked about, like making sure Social Security is notified, making sure Medicaid reports are returned back, making sure that that person has the necessary supports to live as independently as possible. And the most important feature is that we actually cover the whole state. So a lot of services are county based. We actually cover the entire state of New Jersey. So this is us. And then I will break this down and I will answer any questions that you guys have. Okay.
So if we have any questions, you can use the reactions tab and raise your hand, or you can just come off of mute and ask those questions now.
I have a quick question about the pooled third parties special needs trust. The slide said that 50% of the remainder goes to the nonprofit. Does that mean the remaining 50%, I assume, can go to anyone that at the trust that is named, or how does that work?
Sure. So when you have a private third party trust, or when you have a private trust, okay, none of it is retained by a nonprofit. Okay. That is really specific to the pool trust. So effectively, when you create a private trust, you're going to create that through an attorney. You're going to pay that, and you're going to select whatever remainders are there. So the way that would work is, the trust is established, it gets funded at a certain point, typically when the parents pass away, and then the trustee makes disbursements. In this case, Connor will make disbursements throughout Connor's life, and then when Connor passes away, the trustee will do a final accounting and then send that money to the next remainder. Usually it's another family member or something like that. So in this case, let's say Sally, right? So the trustee would not be retaining any money from that trust. So that's a private trust. With a pooled trust, you don't pay anything to get in, so that the trust already exists. So what you're doing is signing a joinder agreement to an already existing trust. So there's no charges there. And then same format. While Connor is alive, you're going to be making disbursements and buying things for Connor while he's alive. When he passes away, the nonprofit is going to retain 50% of whatever's left over. And then the other 50% is going to go to, in this case, Sally. Okay. So that's, if it were a third party pool trust. If it's a first party, so let's say parents didn't do planning and the money went to Connor, and that's why he's in the pooled trust, and it's a first party self-settled trust. 50% is going to be retained by the nonprofit. So all of the same functions, money comes in, dispersed for Connor, throughout his life. And then at the point at which he passes away, 50% is going to be retained by the nonprofit. And then 50% is going to go back to Medicaid.
Okay, thank you.
Okay. So go ahead.
No, go ahead.
Go ahead.
We have a question in the chat.
Okay.
What do you charge for life planning consultations? And are there any pro bono attorneys that help with the legal parts?
Sure. Consultation. So, if we're writing a life plan, there is a fee involved in that. And that's $900 to write a life plan. But it's very extensive. So, it's basically a lot of collaboration with families. And at the end of it, you have about 20 to 25 page narrative with all of the important information embedded in it. So that's one piece. But when we talk about consultations, we don't charge when families call us and talk about their situation. So, if you have, questions and things along those lines, we actually we charge nothing when families initially call us. So we will spend about 1 to 2 hours talking with families very specifically about their situation. This obviously isn't the format to do that, but ultimately the idea of it is to make sure that everybody has the information that is appropriate. That's honestly the reason why we do these seminars. Less to talk about Plan New Jersey services, more to make sure that people understand what guardianship is, what it isn't, what are trusts, what are they not, so we want to make sure that everybody has that. So we don't charge anything when people initially call us. We'll help wherever we can in terms of that. As far as pro bono services, we do a lot of pro bono services. Couple things. One, sometimes courts will reach out to us and this individual doesn't have any resources, but does need a guardian. Our caseloads are significantly less than, let's say, Bureau of Guardianship Services. So, ultimately, we can provide a little bit more handholding, a little bit more individualized service than a larger state agency. So we do take a lot of pro bono cases on. We're well over full right now. But like I said, that's something that we do.
Great, thank you. And someone did write in the chat that South Jersey Legal Services assists with guardianship for non-contested for children turning 18. So thank you for that resource as well.
Yeah.
Another question that came in is, how does Plan New Jersey interact with trust beneficiaries to determine distributions?
Sure. So as far as Plan New Jersey is concerned, every client has a specific trust coordinator. So, they're going to have direct contact with someone who's making those disbursements for them on their behalf. And then those are supervised by our director of trust services. More often than not, a lot of our clients are also receiving case management services. So we're actually visiting them on a very regular basis. So, usually monthly, because families want us to make sure that we're keeping on top of those administrative functions, making sure someone has that access to a safe, stable home, able to get out ahead of problems as they're kind of starting. So, if somebody has some difficulties with residential, they have a case manager that they can rely on and lean on when, things become difficult. So.
Great, thank you. Any other questions? You're welcome to come off of mute or, type it in the chat and we'll relay that question to Jason while we have him.
I have a comment.
Sure, go ahead.
One thing that I'm worried about when opening up a special needs trust fund is that you cannot use the special needs trust fund for food or for shelter. I know that SSI is supposed to take care of those expenses, but it's really not enough money to
Sure.
pay for food and shelter. So what's your suggestion for if you leave all this money in a special needs account, making sure your child has enough money for food and shelter in the future?
Sure, absolutely. So a couple things. One, they're actually working on legislation in regards to paying for food. So that is actually something that is currently being worked on. I can't tell you when that will actually come to fruition if it does. But a lot of what a trustee as well as a rep payee should be doing would be trying to utilize and kind of balance the two functions, right? So if it doesn't pay for food, which and Jen, it does actually, you can use it to pay for shelter under certain circumstances. If someone's on SSI, they're ultimately just going to take a 1/3 reduction in their rent or in their Social Security payment if you're paying for shelter with that. So that's just the same in-kind support and maintenance if, say, an individual was living with their parents. So instead of getting, $700 in SSI, they might get $500, right? But you can still give that support. So that's something that can be paid out of a trust for shelter. Food is still not something that you can pay for, but you have a couple of different options. One, you can utilize an ABLE account because an ABLE account can pay for food. The other thing is that you can rearrange a budget so that you take care of all the other bills to make sure that there's enough money, grocery money in there to help pay for food. So there's definitely things that you can do as a trustee and rep payee to ensure that, everything balances out and a person doesn't flounder, because it's absolutely ridiculous for someone, they have X amount of dollars in a trust, but you can't use it to pay for food, which, makes no sense. So there's different ways that you can do it, of just shifting around budgets. Like, I know a lot of times people will pay a cell phone out of Social Security. Well, you can pay that out of the trust. So that frees up $100 in Social Security money every month to pay for groceries. So just creative budgeting like that. Even like a cable bill. So a cable's ridiculous now. It's like $150 or $200 a month to pay for a cable bill. So if you had cable and cell phone coming out of the trust, now you have $300 extra a month for groceries. So a lot of it is just creative budgeting to make sure the numbers match up and are most effective for the individual.
Thank you. Any other questions? Again, you can unmute, use the reactions to raise your hand or type it in the chat, and we'll get that question over to Jason. Is there anything else, Jason, that we needed to add? No.
I mean, ultimately, the big thing is that, again, we're talking about some fairly complicated situations. Everybody has such a unique situation. So I encourage, any family members to call so they can very specifically speak about their situation. This is not, like I said, this is not necessarily the format to discuss very specific individual situations, but like I said, it's an open offer that if families want to talk about their situation, and we can certainly help you get your plan, make sure that you have all the information that are necessary, so you're in the right space, even if you're not working with Plan New Jersey. And that's why I said we don't really charge for any initial consultations, because we'll spend a fair amount of time making sure that you are as well planned as you possibly could be, even if it has nothing to do with Plan New Jersey. We just want to make sure that, there's no real go-to hub where you can find all the information you need when it comes to trust and Medicaid and Social Security and those things. So, we want to make sure that we extend that offer out to everybody here, that, feel free to call us. We'll get you scheduled to have a conversation about your specific situation.
Great, thanks. You have some thank yous in the chat and some people expressing what a great organization it is. So thank you for that. So if there's nothing else, that will conclude today's workshop on person-centered life planning, who will care for my loved one when I'm gone, from Plan New Jersey. Again, thank you so much, Jason Miller, for sharing your knowledge and your resources. And we will be able to get the presentation, the PowerPoints and the resources through the email that you provided. So thank you so much.
Thank you a bunch.